Joint Tenancy Part 2: Embracing Joint Tenancy as an Innovative Muslim Law. This presentation is based on research and books written by Sadali Rasban on the main challenge faced by Muslims in Singapore on estate matter, joint tenancy upon death of a joint tenant. This is the second part of the topic of joint tenancy. You will have a better understanding why joint tenancy, a civil law, can be embraced by Muslims as an innovative Muslim law. Ultimately, you as Muslim should decide to accept or reject joint tenancy as innovative means of wealth transfer that is in compliance with Muslim law. Objective: the past presentations have shown how the fatwa of rejecting joint tenancy have caused more harm than solving the challenge faced by Muslims. We will also show the reason for the rejection from Mui's perspective. The objective of this presentation is to help the viewer to understand and appreciate joint tenancy from the civil law and Sharia law, Muslim law perspective. Each justification will be elaborated in a logical sense and backed by Islamic European process. Mui's rejection of joint tenancy as Muslim law. Survivorship is not Sharia compliant. Initially, fatwa by Muis rejected the principle of survivorship in joint tenancy, and yet Muis recommended the use of riba al-rukbah, which is the Islamic concept of survivorship. That is, the survivor will take the full ownership of the property when the other joint tenant demise. Gara. Joint tenancy was rejected by Muis because of the presence of one form of gara. The share of the co-owners is not determined in the contract, but recommended a solution, Nuzria, that contained many gara uncertainties in the contract as shown in the previous presentation on Nuzria. Cannot protect other needy legal heirs. Every wealth tool has its limitation, but taking Faraid law as a reference is unjust, as Faraid is only applied to net estate. Are we saying that making a hiba gift to the only daughter during the donor's lifetime is unjust? Because based on Faraid, the deceased sibling, uncle and aunties, who are supposed to receive half of the share of the deceased estate are denied of the estate. Joint tenancy is designed to protect the contracting parties, not the legal heir, who are not the contracting parties. Just like Faraid, it is designed to protect the children from the blood ties to the deceased, but it cannot protect the legally adopted children. It also cannot enforce responsibilities that come with the shares. We should define joint tenancy based on the principle of contract as agreed by the parties in the contract. By this understanding, it shows that Muslims need to use combination of tools in wealth and estate transfer to achieve the ultimate objective of Sharia in wealth estate transfer planning. No one means of wealth transfer can achieve the objective of Sharia by itself. Justification to embrace joint tenancy into Muslim law. Joint tenant can be embraced as a new form of contract in fiqh muamalat, a civil contract that complies with the Sharia. From the hiba al-rukbah perspective, both parties have full equal ownership, sharika al-mulk, and control over the property during their lifetime. That is, one tenant cannot make a decision without the agreement of the other tenant on the property. Both have the choice at a later date after the contract was signed to unilaterally sever the contract with ACE if they decided not to adopt the survivorship principle without the consent of the other party. That is, they can change the ownership to tenancy in common. Tenancy in common is a co-ownership where the share of each co-owner is predetermined, example 50-50. If one co-owner dies, his whole share will be disposed based on Muslim law. That is, the surviving co-owner cannot take over the deceased share like in joint tenancy. They can also in later date adopt the joint tenancy contract again. This feature shows that joint tenancy is just, as it provides space for any joint tenant to change the contract. The survivorship principle gives assurance that the surviving tenant will not lose the shelter, a basic need of life. In most cases, the contract is between husband and wife. Should the husband die, the widow is assured of the shelter, assumed the home is fully paid. It is ideal for the first marriage couple. It removes the complexity of inheritance matters that follows upon death of one of the joint tenants. This is so as the inheritance law, faraid, where there can be large numbers of legal heirs. You may just want a share of the estate by demanding the home to be sold, without considering the consequence of the family losing a shelter. Joint tenancy is in alignment with the government public policy of ensuring that every family have a home. Even upon death of a joint tenant, the family still have a shelter. This public policy is in harmony with the Islamic principle of masala musalla. There is minimum cost and hassle to transfer the home to the surviving joint tenant. This practice is in accordance with Muslim law. Islam do not impose difficulty on its followers. Conclusion. The latest fatwa by Muiz on joint tenancy does not solve the challenge faced by Muslims. It defers a problem to a later date. It will possibly cause more problems and hardship to Muslims in Singapore. Some of the possible issues that will erupt are: the surviving joint tenant who has not complied with the initial fatwa is now at risk of being pressured to comply and distribute the share of the property based on the fatwa. The family will always live in fear, as the other legal heirs may at any time demand the home to be distributed based on the fatwa. When the joint tenant dies, normally the husband, the widow will have to sell the house to accommodate the fatwa. Most husbands refuse to adopt the recommendation in Muiz's latest fatwa to do the Islamic hibah or nuzra deed. They believe they have made their intention clear at the point of signing the joint tenancy contract and are assured that the home will go to the widow as ruled by the Singapore High Court and the Court of Appeal. But should the husband die, since there is no hibah or nuzra document been done, the widow may be under pressure to sell the property due to the latest fatwa. As justified in the previous slides, we see no reason that a civil contract that is governed by the civil law but fulfill the Sharia objective be rejected by Sharia law, just because it did not comply with the classical Sharia way of wealth transfer. The joint tenancy as innovative Sharia compliant wealth transfer mechanism. Joint tenancy should be embraced as an innovative Sharia-compliant wealth transfer mechanism. Muslims should accept joint tenancy without hesitation, just like they accept the buying and selling of goods governed by the civil law. If Muiz accepts CPF nomination as hibah, why can't joint tenancy be accepted as hibah or rukbah? Muiz should stop promoting nuzria as a special means of wealth transfer. Muiz need to review their latest fatwa, as it does not solve the problems but create more problems and confusion. The acceptance of joint tenancy will eliminate or at least reduce the conflict of joint tenancy among legal heirs. This is evident as in the case of CPF nomination. There is hardly any issues to CPF nomination today. This will reduce the possible family conflict on estate in the Muslim community, which is one of the main sources of family ties breakdown in Singapore. Please tell your friends and relatives about this presentation.